Well, hello, I am live. Thank you for joining me. My name is Lior Samfiru. I am the employment lawyer. And more specifically, I'm one of the founding partners of Samfiru Tumarkin LLP. And my firm is one of the largest employee side firms in Canada, probably the largest. And what we do is we help individuals with their workplace issues, whether they've been let go, whether they've been dealing with harassment, maybe their job has changed, maybe they've been put on a layoff, on a leave of absence. We help people every single day, 7 days a week, to resolve these issues, to get compensation, to deal with those workplace problems. And you then may ask, why am I here now? I'm here to do the same thing. I am here live right now to answer questions, to give you some guidance and support when it comes to employment law. So I'm live right now. If you're watching me, I'm here, you're here. I want you to ask your question. Maybe it's for you, maybe it's for a friend, maybe it's an issue that you've always wondered. Maybe you're dealing with a problem right now. Your boss said something or did something, put you on the spot. You don't know how to respond. You don't know if it's legal. Well, no need to wonder. You can ask your question right now. You can type it in, press enter. I'll see it, I'll read it, I'll answer it, and you can walk away with that information. So again, my name is Lior Samfiru. I am the employment lawyer live here at your service to answer questions, to give you some guidance and support when it comes to employment law. Now, before we get started today, let me give you some additional information that you need to have. If you want to reach me and my team off social media, you want to have a private email exchange or a private phone conversation, you want to actually get us to work and roll up our sleeves and to help you, here's what you do. All you got to do is you go to employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. When you go there, number one, you can read a lot about employment law and workplace rights. That's all there. But all the contact information is there. Phone numbers, email addresses, forms, everything you need is right there for you. So the best resource you can have, smartphone, tablet, phone, whatever you want, employmentlawyer.ca. But that's for after. Right now, I'm here live at your service, taking questions, answering questions, hopefully solving as many problems as possible. We always get questions at the end of the session, and then sometimes I don't get to read them all because it's the end of the session. So don't wait. If you're watching, if you have a question, ask it right now. Don't wait 20 minutes and then there'll be a bunch of questions and then you won't have your question answered. You have time right now. Ask the question. Now, I'm going to start answering questions right now. As in between your questions, I'm also going to talk about situations where you may have actually been let go without realizing it. I'll talk about when those situations happen and what you can do about it. It's much more common than you think. But right now, live questions answered. Ask yours. First question from Jihan on YouTube. My daughter's new employment contract showed restrictions on severance pay for termination and temporary layoff. So how can a lawyer help her remove that restriction? So great question. First of all, if you're accepting a job or if you're working and you're presented with a job offer letter, a contract of employment, you may see terms there that are not favorable. Okay, and it's not just about how much your salary is and how many weeks vacation you get. There's other terms that are problematic. The example that Jihan brought is a great one. It could potentially, an employment agreement can potentially limit your future severance. That could cost you tens of thousands of dollars. It could be the difference between getting 2 months severance or getting 24 months of severance. Tens of thousands, maybe hundreds of thousands of dollars of difference. So what do you do if you're presented with an agreement like that? First of all, you need to understand what it says. You need to reach out to me, to my team. We can review it and tell you, is there a problem with this document or isn't there? If there is, we'll talk about how we negotiate those terms. They are negotiable. You may not think that they are, but believe me, I do this every day. I've done this thousands of times. They're absolutely negotiable. We'll talk about how to do that. Final thing I'll say is this. Maybe 5 years ago, however long, you signed an employment agreement that limits your severance, and now you've been let go, and you think, crap, I'm stuck. I've signed that agreement. Now I don't get my full severance. Not so fast. We may still be able to get you out of that agreement and get you your full severance. There's many ways to do that. In fact, that's fairly common. So if you've been let go and if you're looking at that employment agreement and it's being held against you now, hey, you remember when you signed that agreement? Now we're relying on it. Well, not so fast. Call me. Email me, whatever you want. We may be able to get you out of that agreement. And again, that could be tens of thousands of dollars in severance. So you know how to reach me, of course, employmentlawyer.ca. Great question, Jihan. Any follow-ups, just ask. Next question today comes from Carrie on YouTube. Can an employer cut off your medical coverage if you are on a temporary layoff? My daughter is diabetic and has lost access to her benefits. So here's the thing, Carrie. Your employer doesn't actually have a right to put you on the layoff to begin with. What I mean by that is, and that's actually one of the things I was talking about situations where you're let go without realizing it, is that your employer doesn't have a right to put you on a layoff. So just by putting your daughter on a layoff, she may be able to treat that as a termination. We call that constructive dismissal. There's no automatic right to put her on a layoff. So it's illegal. So you're asking me, if they're doing something illegal, can they also cut off her benefits? Well, if what they're doing is illegal anyway, it doesn't become more illegal, right, by cutting off her benefits. So if what she wants is to wait for her job, there's not much that she can do. So she has two options. She accepts what her employer is doing, no benefits, and she waits until they call her back. Or she can treat that as a termination. She can do that now. Okay, if she can treat that as a termination now and get severance because it's not legal. But those are her options. It's not the cutting of the benefits that's illegal. It's putting her on a layoff to begin with that's illegal. Okay, hopefully that makes sense. Feel free to ask a follow-up question, Carrie. For those joining me right now, welcome aboard, guys. My name is Lior Samfiru. I'm the employment lawyer. I'm here live answering your questions. A bunch of questions are coming in right now. I'm going to answer them, but don't be bashful. You have time. Ask your question. You see how simple it is. Type it in, press enter. I'll read it and answer it. Next question from Jay. Very, very simple. Jay on YouTube. I want to make sure that I'm on the right path here. I've been harassed, belittled, and whatnot, and consistently being asked to quit and accept a bogus severance, etc. Well, today I finally elected to go on a stress leave. Was this a good decision while in limbo, waiting to speak with you guys? I simply couldn't handle the employer constant harassing. So here's the thing. If you can establish, Jay, that you've been harassed, mistreated, bullied, then you can treat that as a termination, as a constructive dismissal. And you don't have to go on a medical leave. We can get you out of there with full severance and potentially other damages as well. It's not a bad thing to go on a stress leave. My issue is always, what do we have to prove it? Because remember, the people that are harassing you, they're not going to admit it, right? They're going to lie. They're going to say, no, it never happened. So do we have emails, recordings, witnesses, anything like that? If we don't, we can talk about how we create that, okay? If you do, you may be able to take legal action right now because you have a right to be in a harassment-free work environment. It's an important right that you and everyone else has. But when it comes to harassment, always assume that whoever's harassing you is not going to tell the truth. So you have to prove it. So always the question is, how do we prove it? If you can prove it, we can act on it now, today, okay? So hopefully that makes sense, Jay. Let me know if it doesn't. Great questions today. My God, I love these questions. Very important questions. Question on Facebook from Melinda is the next question. I'm returning to work from a maternity leave and have been told I will have to take a different position. It's less pay and fewer hours. Are they allowed to do this? Gosh, I can't believe that in 2022, employers still do this. The answer is an emphatic no. They cannot do that. It's not legal. When it comes to parental leave, it's very, very simple. You have to be taken back to the same job you had, same hours, same pay, same benefits, well, same everything. And anything short of that is illegal. That could be considered a constructive dismissal. It could be a violation of employment standards. It could be a human rights violation. It's illegal. So no, they cannot do that. So Melinda, if your employer is doing that anyway, you really have to get on the phone, call me, or send an email. We can either get your employer to realize the error of their ways and back off, or we can get you compensation. Either way, you have rights. It's not legal. And an employer really these days should know much, much better than even trying to do that. So Melinda, please reach out to me. You see the address below me, employmentlawyer.ca. Again, for all of you as well, if you want to connect with me and my team anytime, employmentlawyer.ca, phone number, email address, forms, contact forms, it's all there. All right. Thank you for that. I'm going to continue answering questions. Again, ask yours. We still have time, guys, so don't be waiting for the last minute. I can already sense it's going to be a situation where I get several questions at the last minute and I won't be able to answer them. Okay, next question. Let's see, from Carrie. So Carrie was asking about a temporary layoff for her daughter. Said they did send her a letter asking her to sign off on the layoff and offered to reinstate her benefits if she did so. Should she sign? Well, again, if she wants to accept the layoff, she can sign. That's up to her. But what she can also do is treat it as a termination because it's not legal. So it's not about should she sign. It's about what does she want. Does she want to continue working? And that means that she'll have to wait. How long? Who knows? It could be another few months. Or does she want to say enough is enough? I'm treating this as a termination. If that's what she wants to do, Carrie, she needs to call us. Cannot sign. She has to give us a call in that situation. Again, for her to reach out to us, for you to reach out to us, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca. Okay, Jay had a follow-up. Jay was writing about workplace harassment. We'll be sharing my proof of harassment, etc., multiple screenshots, recording. Okay, my employer even put in writing made fun of my mental health and stress leave. So, Jay, if you have those things, my God, that's a human rights violation, what you've described. It's a constructive dismissal. It's wrong. It's illegal. But the good news is, if you have that, it makes it very easy for us to really deal with this and hammer the company for what they've done that's illegal. So yes, you said you have an appointment with us, then you got it. We'll help you. We'll make sure that we get together and resolve this. And for anyone else, again, if you want to connect with me and my team in Ontario, in BC, in Alberta, very, very easy to do. The address, you won't forget it, employmentlawyer.ca. Again, employmentlawyer.ca is the place you go to connect off social media for that private conversation. Okay, next question on Facebook from Stephanie. My husband was laid off and was told it was due to work shortage. I found his job posted on Indeed a week before his layoff. Can a company do this? Well, again, if I'm assuming you're not talking about a temporary layoff, but a permanent layoff. In other words, they let him go, and they said it's due to work shortage. So if that's what happened, yes, they can do that, because a company can generally let you go for any reason or no reason, as long as they pay proper severance. So if they are lying about the reason, that may make them liars and bad people, but it's not illegal. Okay, and a company does not have to give a reason or an honest reason or have a reason, as long as they pay severance. But here's what I want you to think about, Stephanie. I can almost guarantee you, I haven't spoken to you or your husband, but I can almost guarantee you that whatever severance he was offered is a lot less, not a bit less, a lot less than what he's owed. Why do I say that? Because that's true for over 90% of people. 90% of the time when someone has been let go from their job, whatever severance they're offered is not even close to being what they're actually owed. So what your husband needs to do is to give us a call ASAP. Okay, not sign anything. Please don't. Let us assess what he's owed, and if he's owed more, which he's extremely likely owed more, we can help him get what he's owed. So it's not the fact that they lied to him. Again, I think that lying is a terrible thing, but it doesn't really matter what I think. What matters is whether it's illegal. Not illegal, but they have to pay him severance, and they have to pay him his full severance. And by the way, I think this is a good opportunity to tell Stephanie and to tell everyone else, how do you find out how much severance you are owed? You may say, well, how do I know if I'm owed 2 months or 10 months or something else? You can do that right now and find out. Grab your smartphone, your tablet, your desktop, whatever device you're using, and you go to pocketemploymentlawyer.ca. I'll give you that address again. It's pocketemploymentlawyer.ca. And when you go to pocketemploymentlawyer.ca, you'll see our severance calculator. You see that address right away, but below me, pocketemploymentlawyer.ca. We have our severance calculator tool. You know what it does now based on the name? It calculates and tells you how much severance you are owed, whether it's 8 months or 24 months or anything else. It's free to use, completely free. It's completely anonymous. No one will ever know you were there. It takes seconds, and it's such important information. Now, you would want to use it if you actually lost your job, of course, to know how much severance you're owed. But you also want to use it if you haven't lost your job. Maybe you're curious and you want to just have this information. Or maybe you're worried about losing your job. You think something is coming up and you want to be prepared. Again, pocketemploymentlawyer.ca. I can almost guarantee you, and you'll see this when you use it, that the amount that comes up, the amount that shows you what you're actually owed, is a lot more than what you believe it is. You may think, oh, I'm probably owed a month's severance, and you'll see you're owed 6 months. Check it out for yourself. Don't believe me, try it. pocketemploymentlawyer.ca. I'm Lior Samfiru, the employment lawyer. I'm answering questions live. Ask yours. I'm going to continue answering questions. I'm not going to ask them. I'm going to answer them. Next question on YouTube from Archie. If I have an annual salary increase as part of my employment contract, are there any circumstances where my employer can opt out of providing this to me, like work shortage? No, the answer is they cannot. Now, if your employment agreement is unequivocal and says you will get the salary increase on January 1, 2023, not maybe, not potentially, not in our discretion, if it simply makes it clear that come this date you are getting the salary increase, they have to provide it to you. Now, the question becomes, well, despite what I said, what if they don't? Well, if they don't, you have a right to take legal action against them. It may not be something you want to do, so you may give up on that raise. But if you're asking me, is it legal? The answer is absolutely not. I don't care if it's a work shortage. I don't care if it's because they're changing direction of the company. No, they have to give it to you. But if they don't, you absolutely can take legal action. You will be successful, not even difficult at all to do. In fact, it could just be a letter from me. Forget legal action. One letter from me, you'll see how fast they do it. You just have to be comfortable doing that. If you want to do that, if you're ever in that situation, happy to help you. I've done this many, many times. It's your call. Okay. Let's see. Great questions today, guys. Love those questions. Okay, I answered that one. Next question is from JR. What is the best way a company can put an employee on notice for being released? Is it through a voluntary completion of a company exit form, or could you explain the details of an exit form? Well, no, there's no exit form. If a company wants to give an employee notice of termination, they just send a letter saying, we're giving you notice of termination, effective whatever the date is. That's all they need to do. The employee doesn't need to sign it. The employee doesn't need to complete anything. It's simply a letter from the company addressed to the individual saying, Bob, we're letting you know that effective August 21st, we're letting you go. It could be effective immediately, or they could give advance notice of the termination. The key here, of course, is the severance that they owe. So there's no magic to the notice. There's no requirement for an exit interview. By the way, if you're ever being told that you have to do an exit interview, you don't. You can say thanks, but no thanks. That's, some employers like to do that. That's great. But you, the employee, do not have any obligation to participate in an exit interview. There's nothing they could do to force you. There's literally nothing there. But an employer can give notice in writing. The key always is the severance that the employee is owed. And for employees and employers, to find out what that severance is, I've mentioned that already, pocketemploymentlawyer.ca, the place to go to. All right, next question on Reddit from Winter. I refuse to take a 25% pay cut, can't blame you, and sign a new employment contract, and now my employer is terminating my contract. What should I do next? Well, what you should do next is call us, because they're allowed to terminate your contract, right? They can terminate your contract because it's a Wednesday. They can terminate your contract because the leaves are green and not gray. They could do all that, but they have to pay proper severance. So the fact that you wouldn't take a pay cut doesn't allow them to avoid paying you severance. They still have to pay you full severance. So they may say, well, because you didn't accept, we can let you go and not pay you anything. Nonsense, ridiculous, silly, no, no, no. So you give us a call, we'll review everything. And if you're owed compensation, and guess what, you are, then we'll make sure you get it. Not complicated, not long, not difficult. Okay, that's what you have to know. Winter, looking forward to connecting with you and to connect with me and my team. You see that address on your screen right now, employmentlawyer.ca. Again, employmentlawyer.ca, the place to go to have that chat, to connect with me. to get me and my team to roll up our sleeves and get to work. I can answer questions here on social media. If you're watching me now on Facebook, YouTube, Reddit, wherever you're watching me, I can answer questions, but I can't actually get involved and do something with your employer. To do that, to get me to do that, to get my team to do that, easy. Connect with me through employmentlawyer.ca. All right, continuing with those questions. By the way, we have a few minutes left. You still have time. Don't wait till the last minute. I've said that before. I know that there's people that are going to wait till the last minute. They're not listening. Ask your question right now if you want your question answered. Jackson on YouTube is asking, I'm in the Windsor area and need to reach out to you guys. What's the best number and who? Well, as I've been saying, all you do is you go to employmentlawyer.ca. So when you go to employmentlawyer.ca, the phone number is going to be there, email address is going to be there, a form is going to be there. Everything you need to connect with me and my team is right there. We even have a live chat feature, which you can talk live on the spot with one of our intake people. But employmentlawyer.ca, Jackson, is all you need to know to connect with us. It's easier than me giving up numbers and you may write it wrong. So just remember employmentlawyer.ca. It's all there. All right. We help people across Ontario, across BC, across Alberta. So whether you're in Windsor or Ottawa in Ontario, it doesn't matter. We got you covered. Next question from Bill on Facebook. Is recording a conversation with my employer legal? Good question. I get that asked fairly often. And the answer is yes. It is legal for you to record a conversation that you are part of. So if you're recording yourself speaking to someone else, you can record that conversation even if the other person or people don't know that you're recording it. You have a recorder in the pocket of your shirt and they don't know you're recording. You're talking to someone. You can record that. There is no law that prevents that. What you are not allowed to do, what is completely illegal, is to record other people speaking. To leave the recorder in the office and record other people speaking in that office. You can't do that. That's completely illegal because you're not part of that conversation. But if you're recording people that you're speaking to, that is legal. And in some cases, by the way, that may be very helpful. It's a way to, if someone is mistreating you, talking badly, harassing you, you can record that happening. If your boss is trying to pressure you to leave or threatening you, or if you record that, how helpful would that be, right? Because they'll deny it. They'll deny it, but a recording doesn't lie. You have that recording. It could be a powerful tool. I've resolved many, many cases just by virtue of the fact that I had a recording that avoided everyone else being able to lie. All right. So hopefully that answers your question, Jackson. Happy to connect with you. Now, continuing to, we have a few more minutes left. My name, by the way, is Lior Samfiru, the employment lawyer. Very easy to remember. Just call me the employment lawyer. And I'm here live answering questions for you. If you're in Ontario, in BC, in Alberta, have a question about employment law, workplace rights, your job, your severance, whatever that is, ask it right now. All right, next question then comes from Claude on Facebook. I have been on leave for the last 2 years. Now that the IDEL, the infectious disease emergency leave, has changed, should I be called back? What happens if I'm not? In fact, Claude, you should have already been called back last week because the leave ended as of the end of July. Right now, we're, I think, the 10th of August as we're doing this live here. So you should have been called back. If you're not called back, that's a termination of your employment. You're owed severance immediately. So you can follow up with the company and see what's what. But otherwise, you can absolutely say, no, I'm done. By the way, they didn't even have a right to put you on this leave even to begin with, despite the infectious disease emergency leave. But that's history now. Now that it's over, they have to have you back to work. It's illegal not to. So you want to reach out to me as soon as possible if you're not being called back to work. Same with you at home. If you're in Ontario and you've been put on an infectious disease emergency leave and you are not called back beginning of August, you got to call me, okay? Not next month, not next week. Call me now, okay? employmentlawyer.ca to connect. All right. Next question from JX2 on YouTube. What's the approximate cost to get a small contract drawn up for an employer? Again, depending on the contract, what needs to be in it, it's a few $100s. It could be anywhere from $300 to maybe $700, depending on the complexity of the contract. It could be more if it's a big contract with a lot of different things, share options and allowances, etc. But a simple contract, you're looking at a few $100s. It's not a big investment. But by the way, for an employer, I'm going to put my employer hat on for a second. The single most important thing that you can do from an employment law standpoint is have proper employment agreement in place with all your employees. I often tell my employer clients that if they all had proper employment agreements, they'd never need to call me again. Lucky for me, most of them don't listen, and they still have to call me because they didn't do what I told them to do to begin with, which is have proper employment agreements. So very important to do. JX, happy to help you. And by the way, for an employee, forget about what I said. For an employee, the opposite is true. You don't want to have a proper employment. You don't want to have any employment agreement. You want to start a job on a handshake, or you write something on the back of a napkin or with an email. All of those are 10 times better than having a proper full 5, 8, 10-page employment agreement, because I can promise you in that employment agreement, there's going to be plenty of terms that are problematic for you, the employee. So employment agreements, extremely good, extremely important for employers, not good for employees. Okay. All right. Continuing on today. Next question comes to us from Facebook, and it's from Patrick. My manager has threatened me several times when I mentioned looking for another job. Is it possible for them to prevent me from taking a new position? The stress is really getting to me. First of all, I always think it's not a good idea to tell your employer that you're looking for another job. Nothing illegal. You can absolutely do that. There's nothing illegal, but it's going to create friction. And if you're going to leave, you can leave, but no, I wouldn't tell my employer that I'm looking for another job. Why create that friction, that conflict? And I just think it's unnecessary. I would simply give them notice when I'm ready to leave. But to answer your specific question, well, they can't prevent you from taking another job. What they can do is they can refuse to give you a reference, or they can give you a bad reference as long as they're not lying, right? But that's the only thing they can do. You can work wherever you want, and there's nothing your employer can do in that respect. But just generally speaking, in my view, not the best idea to tell an employer, hey, just so you know, employer, I may be leaving. I'm looking for another job. It's just going to create conflict, and it's not necessary to do that. Okay, so hopefully that helps make sense. Guys, I think that's the time that we have for today. Well, you know what? Before we do that, follow-up question from JX. Are there employment regulations in the Northern Territory similar to those in provinces, or are they much different? Couldn't tell you. Okay. We operate in Ontario, BC, and Alberta. I have no idea what the laws are in the territory, so can't say. You have to get advice there. Guys, this is the time that we have for this session. Thank you very much. A lot of great questions today, a lot of different interesting topics that I know many people are dealing with, so I'm glad that you were able to ask those. Listen, I'm going to be turning off my webcam here on my laptop, but I'm not going anywhere. I'm going to get on my other computer and get to work to make sure that I help people and answer more questions. So if you want to connect with me and my team, don't wait until the next time we're on social media. Reach out to us now so we can have a private chat. You can do that through employmentlawyer.ca. Guys, always a pleasure to be back here and to answer questions. I am Lior Samfiru, the employment lawyer from Samfiru Tumarkin LLP. Employmentlawyer.ca is the place to go to always. And until next time, guys, thank you. Enjoy the summer, and we'll talk soon.